All right, thank you, Lindy. So I'm going to do this a little bit different than some of the speakers and panels that you've had so far at the ClearanceJobs Connect conference. I am going to urge you to interrupt me with questions, either by raising your hand if you're that polite, or by just shouting stuff out. That's cool too, because I'm here to answer your questions. Yes, I have a prepared presentation, but I can absolutely get through it in the half hour that Lindy has given me. I pride myself on being able to basically bring it home within the minute, and you recall that I've done that the last 2 times. So I will not be thrown off if you ask a question that is important to you, and I'll just simply move to the part of my presentation that covers that. So please feel free to ask whatever question you have about the established administrative processes. I prefer using the term established administrative process rather than due process, because due process implies a constitutional right. And in 1988, the Department of Navy versus Egan case, the Supreme Court said there is no right to a security clearance. So a security clearance, the eligibility for access to classified information, is not a constitutional right. What is a constitutional right is to be treated fairly along the way. And that's where the one other Supreme Court case that you need to know about comes into play. That's from 1959, and that's the case of Green versus McElroy. Now, what Green versus McElroy was about a process that existed from 1947 until 1959. It was the clearance process that you see depicted in the movie Oppenheimer. How many of you have seen the movie Oppenheimer? Okay, I see Lindy's got her hand up, and I know that she's seen it. The reason I ask is because the scenes in the movie Oppenheimer that depict the clearance process from that time period are remarkably accurate, with a few of Christopher Nolan's artistic choices that maybe don't completely comport with what happened. But for the most part, the thing that mattered was that when you see Oppenheimer being asked questions based on documents that he's not allowed to see and that his lawyer's not allowed to see, that was true of the process from 1947 to 1959, and really into 1960 for reasons that I will explain. So right after Oppenheimer came out, and if you weren't part of the Barbenheimer phenomenon where you went and saw Barbie and Oppenheimer on the same day, which I'm told was a thing, you might have heard a podcast that Lindy described her reaction to the Oppenheimer decision, and being clearance process nerds, we had obviously both seen that. So in a podcast in August of 2023, Lindy asked a question, and it was a rhetorical question out into the ether. But what she said was, I need Perry Russell Hunter to tell me that this doesn't happen anymore. Right? That was, and I just want to say that, first of all, don't worry, Lindy, it doesn't happen anymore. And Executive Order 10865 is the reason. And Executive Order 10865 was signed by President Eisenhower in February of 1960. So just 7 months after Green versus McElroy. Now, why did that happen? So history is important, and I really want to stress here that when we talk about administrative due process or the established administrative processes that contractors get, it's really important to understand how it got that way. Because what Eisenhower understood, and I've always appreciated this about Dwight Eisenhower. I mean, he might have helped win World War II, but the thing that really stands out for me is that in that 7-month window after Green versus McElroy, he was insistent that Congress should not be making the standard, that it should be an executive branch function. And I think he's right about that constitutionally. But what the Supreme Court had done in Green versus McElroy said, listen, we know that what happened to Green was unfair. Basically what happened was 5 confidential sources told the government that Mr. Green and his wife were communists. And the reason, and this is, in the 1950s, the Red Scare, McCarthyism, if you wanted to do somebody in, you accused them of being a communist. And Green couldn't see who had said that or what they'd said. And it turned out that part of the mistake was that it was based on the false impression that being part owners of 103.5 WGMS, the good music station. It was a classical music station. It also broadcast Redskins games. Sounds very wholesome, but according to the House Un-American Activities Committee and the FBI, it was a communist front. It wasn't. But people thought that. And so these accusers were basically repeating wrong things that they'd heard. Green couldn't defend himself against it and ended up losing his eligibility until the Supreme Court told the government to put it back. And so that's the last time that you're going to see the Supreme Court telling us in the government to put somebody's clearance back. And I predict that because with Green versus McElroy, you then have the follow-up years later in 1988 of Department of the Navy versus Egan, which basically said we in the courts are going to defer to the expertise, the substantive expertise in government. In other words, if we in government decide that somebody isn't trustworthy for any number of reasons under the 13 guidelines found in Security Executive Agent Directive 4 or SEAD 4, then that's going to be dispositive as long as we give them a fair process. So a lot of what I'm going to be talking about today is process, not so much substance. I'm also going to talk about substance because since Lindy has called my presentation a legal update, I do also have to talk to you about weed and also CBD. Because there are some legal aspects of that is important for the cleared population to know about. But for the most part, my conversation is going to be about process. Why process? When you saw Mark Fraunfelter and Matt Eanes up here, they were talking about clearance reform writ large. And clearance reform writ large is everything. Clearance reform writ large especially talked about those 5 different levels of trusted workforce and the 3 tiers of investigation that go with them. And what you need to know is that the due process or the established administrative process that goes for each population is not tied to that 5-tier or 3-tier model. It's instead tied to the population of what the job is. And let me explain why that is. Due process or administrative process is not tied to level of risk or level of security. It is instead tied to impact on employment. So contractors have enjoyed for now 64 years a process that bears in mind that if you lose your eligibility for access to classified information, chances are you're going to lose your job because you've been employed to do something that requires access to classified information. In that model, and the model that has stood the test of time, the security clearance decision does not happen until the person has had their opportunity to appear personally and present evidence. That is set out in Executive Order 10865. So for industry contractors for 64 years, the denial or revocation cannot happen until the person has been offered the opportunity to have a hearing. That was not true and is still not true, but will be changing for service members and civilians in DoD. Now, I recognize this is a contractor audience. I'm mostly going to be focusing on contractor cases, but you should be aware that for the entire past 64 years, there has been a difference between the administrative processes that contractors get and the administrative processes that service members and civilians get at DoD and the other departments and agencies. By the way, one of the reasons that I'm here is that DOHA doesn't just decide DoD contractor cases. It also decides the contractor cases for contractors performing work on behalf of 32 other federal departments and agencies. In fact, the one exception at the collateral level is the Department of Energy, which has an Office of Hearings and Appeals that is like mine, just a lot smaller, that handles the Department of Energy's labs, the employees of the national labs, the contractors of the national labs, and the Nuclear Regulatory Commission. And again, they have their own program because they have their own types of classification and different classification than everybody else. Practically speaking, though, the administrative due process that Energy gives to its contractors is the same as the process that DOHA gives because it's driven by Executive Order 10865, the Eisenhower Executive Order. That has stood the test of time. It's been amended in some small ways, but they're superficial. They're mostly just renaming things. The process of the opportunity to appear personally prior to denial or revocation, the opportunity to be given a statement of reasons that's as detailed and comprehensive as the national security will allow. In other words, it's SORs, or statements of reasons, are unclassified. You obviously would make no sense to create a classified notice document, so we don't do that. But at the same time, it's up to the individual. If the individual doesn't want a hearing, they don't have to have a hearing. They don't necessarily, they can actually have their clearance denied or revoked on paper if they choose that. And there are some people who choose that. But the right has always been there. For service members and civilians, it has not been that way. What will change, and it's the result of a memo signed by the Undersecretary of Defense for Intelligence and Security, Ronald Moultrie, back in April of 2023, is that going forward, service members and civilians will have an opportunity to be heard prior to denial or revocation. So the processes are inching closer together over time. DOHA also currently provides the opportunity to appear personally to service members and civilians, but it's just, on the current process, it's after the denial or revocation has already taken place, and it's a recommendation to a Personnel Security Appeal Board at one of the services, or in OSD, it's the Washington Headquarters Services. Why that matters is because for individuals, they're getting different procedural rights. They're being judged by the same substance. The substance is SEAD 4, the Security Executive Agent Directive for Common Adjudicative Guidelines. Now, the nice thing about the Common Adjudicative Guidelines is that starting on June 8th of 2017, this was the first time ever that the federal government was literally judging all security clearance eligibility cases to the same standard. Previous to when Jim Clapper signed SEAD 4 in December of 2016, there had been a different standard for collateral and SCI. The SCI standard was found in ICPG 704.2. ICPG 704.2 actually had a more lenient standard for foreign preference, especially in the handling of passports. How many of you remember the old passport standards, where you had to surrender, destroy, or invalidate the foreign passport? Remember that? And if any of you who served as industry FSOs, you remember having foreign passports in your safe, which it didn't really make a whole lot of sense, but it was still better than the previous standard, because the previous standard was just a DOD-only standard that said, surrender the passport. And what that meant was that people were surrendering the passport to the embassy or consulate that had given it to them, which meant that we were flagging, inadvertently, flagging our cleared people to foreign countries. In some cases, foreign countries where it was a really bad idea to do that. And on a practical level, the current standard makes so much more sense, because now it's what I call the tell us about it standard. If you have a foreign passport, great, tell us about it. Now, why would you have a foreign passport? Well, if you're a dual citizen, you might be required to have a passport of the country of your dual citizenship in addition to your US passport. That's fine. By the way, that has never been disqualifying. Dual citizenship was never disqualifying. SEAD 4, for the first time, actually makes that explicit. It had always been implicit because there was never any disqualifier for dual citizenship. But it's one of the myths that I've been wrestling with for the last 20 years, because people think that there is a bar on dual citizens, and there isn't. But what we do expect is that people will enter and leave the United States on their US passport. Now, that's just US passport law. So SEAD 4, and before it ICPG 704.2 for the 9 years before, where the intelligence community actually had it right, simply replicates US passport law. And it also says, if you've got a foreign passport, you don't have to do anything. You don't have to surrender, destroy, or invalidate. You don't have to surrender it at all to anybody. But just tell us you have one, because we might want to look at it. Right? That makes sense. But you also have to enter and leave the US on your US passport. That's US passport law. It's also the passport law of every other civilized country in the world, right? So that's where we were having a problem, because other countries were expecting their citizens to enter and leave their countries on their passports. And we were actually making it harder for them, and we were flagging them, and we were alerting the other country to the fact that they were clearance holders, because the other countries were very quick to figure out that that was what was happening, right? It was really bad OPSEC, the way we were implementing it. So with that said, Seed 4's Guideline C is a lot better now, and it aligns with Guideline B, which is the Foreign Influence Guideline, by really talking about heightened risks. So the idea that an exercise of foreign citizenship really needs to involve something that creates a risk to national security, not just that you happen to be a dual citizen or that you happen to have a foreign passport. We're really now looking to see what's the impact on national security, because that's what we should be doing. And so now the guideline makes a lot more sense. The other guideline that I will be talking about briefly is Guideline F, the financial guideline. Now, how many of you remember Alder James? Okay, so Alder James got caught in the early 90s, and by the mid-90s, when President Clinton was signing Executive Order 12968, one of the things that was happening was we realized that Alder James had spied for money, that other people might be spying for money, and that it would be a good idea to actually know about people's finances. Unfortunately, what that has led to is that with the old-fashioned background investigation where we just got a credit report and now continuous evaluation and now continuous vetting, that's part of the records that we pull. We get a credit report. That is still the low-hanging fruit in the investigation. Even though our methodologies have modernized, we still have a superabundance of cases where it looks like, oh, there might be a problem, and then we figure out that, oh, no, that actually can be mitigated. Now, why are we figuring out in so many financial cases that, oh, this looks like a problem, but it's actually not? The credit report doesn't report context. The credit report only reports debts. The guidelines and the whole person concept is all about context. So, for example, you get somebody who has something on their credit report, and we saw a lot of this after 2008, 2009 with the financial downturn, the mortgage crisis. A lot of people who were good people who hadn't done anything irresponsible suddenly had credit reports that looked different, looked strange. The second mitigating condition under Guideline F in Seed 4 is that the person has had circumstances beyond their control and has acted responsibly under the circumstances. Now, why did I emphasize the word and? Whenever we draft something in a regulatory context, when we say or, we mean it could be this or it could be this. When we say and, it means it's got to be this and this. We need to have both things. So you have to have had circumstances beyond your control and acted responsibly. You don't just get to throw your hands up and go, oh, circumstances beyond my control, I don't have to do anything now. But that requires getting more information, what Paul Harvey would call the rest of the story, right? And the credit report doesn't supply that. This is something that I think can be just expanded more generally about CV. CV will give you a hit. It will tell you that there's a problem. And CV was super important in the wake of the Alder James case, and also in the wake of the Aaron Alexis case. Both of those were cases where bad stuff was going on, bless you, and we didn't know about it. And so the opportunity to know about what's going wrong with someone earlier through continuous vetting has been truly revolutionary. Now, just yesterday I was talking to the ACBI, the Association of Certified Background Investigators, and what we were talking about, and it's a thing that comes up with them often, is CE and CV aren't going to put background investigators out of business. It's actually going to make their jobs much more interesting, because now what you're doing is you're running down something that may or may not be a fact, or that may be a fact that has a rest of the story to it. And so you're not just striking out blindly, going into neighborhoods and asking people, so what do you think about your neighbor? Well, gosh, he doesn't mow his lawn as often as I would like, and those bushes are getting kind of, I don't know about him. I don't like the cut of his jib, right? You know, that kind of background investigation is gone, mercifully. But what replaces it is the way that people interact in the world now. So I remember during clearance reform back in about 2007 or 2008, saying, you know, the neighborhood investigation's got to go, but it's got to be replaced with something, because the internet is the new neighborhood. And so Seed 5 reflects that. Seed 5 is the Security Executive Agent Directive that talks about going out and being able to gather publicly available information. So, an example of that might have been somebody who posts online that, hey, just breached the Capitol, having a great day, right? That's going to be a thing that's publicly available because they didn't protect it. By the way, we're not looking at password protected stuff. So there are countries, by the way, that do that. There are Commonwealth nations like New Zealand and Australia that will actually have a security person sit down with a cleared person and say, give me all your passwords. We're going to look at your social media together. You imagine doing that in the United States? No. So SEAD 5 is very clear. It's publicly available information. But even with publicly available information, there's still a question of, all right, so what does it really mean, right? Because context, again, is super important. How many times have you seen a news item about a celebrity or public figure where a tweet or a social media posting got taken out of context, right? So we don't want to do that in the personnel security process. We want the personnel security process to be based on verifiable facts. And so that's where the investigation comes in. The investigation is meant to nail down what we think we know from continuous evaluation and continuous vetting and make it into something that is real, that is actionable, and that is also defensible. Because remember what we learned from Department of Navy versus Egan. They're not going to courts aren't going to second guess our judgment about whether or not someone is trustworthy if, and only if, we have addressed the concern fairly. That means not doing what happened to Green in Green versus McElroy. That means not doing what happened to Robert Oppenheimer during the same period. That means not doing what happened to Abraham Chazanow during the same period. Oh, wait, you don't know who Abraham Chazanow is? Well, he's the subject, with the name changed obviously, of a 1956 Hollywood movie starring Ray Milland, Ernest Borgnine, and Nina Foch. Remember Nina Foch? She was the older woman in American in Paris who seduces Gene Kelly. Right? I mean, this is A-list Hollywood people in a movie that nobody's ever seen. I didn't even ask for a show of hands because I only know that Lindy and I would raise our hands. But no, seriously, how many of you have seen Three Brave Men? You have? Oh, that's super cool. Okay. All right, so anyhow, that's super cool. And by the way, you can watch it for free because even though it had an A-list Hollywood cast from 1956, it was about a process that existed in 1956. It was scrupulously, carefully written. I mean, this was really good screenwriting. Unfortunately, it wasn't particularly interesting to most people. There's no car chases, no explosions, no sex, nothing. I mean, it's basically about what happened to this man and his family when he was falsely accused of being a communist. And in the 1947 to 1959 version of the process. So it's like Oppenheimer in that sense, and it depicts the same process, which was, we're not going to show you what we have against you, but we want you to answer a bunch of questions about the thing that we're not going to show you. Do you remember what Matt Eanes said up here on this stage? For those of you who weren't there, I'll tell you what he said. Matt Eanes said that one of the things that he's concerned about from the PAC PMO perspective is to make sure that the clearance process is fair and it allows for disclosure to the subject of the information against them. Because now, in addition to whatever background investigation is done, there are now these continuous vetting or continuous evaluation hits where the subject is going to be able to provide the rest of the story. So that needs to happen at the investigative stage. It needs to happen at the adjudicative stage, and then it's our responsibility at the due process stage to also ensure that the hearing is fair. So I'm going to tell you about one more federal case, and this is not a Supreme Court case, it's a Federal Circuit case. The Federal Circuit is the U.S. Court of Appeals that's above the Court of Claims. Why that matters is because they see employment cases, and this was a case, Wonders versus Army. It was a civilian employee of the Department of the Army who had his clearance revoked by DCSA, or what was then the DSS CAF, or actually then the WHS CAF. And what had happened was he had some I'll say mental health issues, behavioral issues, that had started to manifest in the workplace. So there was a really damning psychiatric evaluation about him. There was also a scathing letter from his commander saying basically, I don't trust this guy, I don't want this guy to have eligibility. So fair enough, but neither of those things had ever been given to Mr. Wonders. He had no idea what was going on. And the statement of reasons, while somewhat detailed, really didn't provide him with the information that was being used against him and the information that had caused him to have his clearance revoked. So we get that case at DOHA. And the first thing we did is we said, wait a minute, Mr. Wonders, do you have this psychiatrist report? Do you have the commander's letter? No, I don't. We went back to the Army and said, you got to release these documents to Mr. Wonders before we can have a hearing. Otherwise, it's not going to be fair. And one of the things you'll hear is like, oh, DOHA takes too long. Yeah, at times like that, you want us to take longer because rushing him to a hearing would have made the difference in the federal case, because guess what the Federal Circuit said at the end of the day? Yes, our administrative judge concluded after hearing from Mr. Wonders, after he'd had a chance to see the psychiatric report and the scathing commander's letter, that no, he really shouldn't have eligibility. So administrative judge recommended upholding the adverse decision of the CAF, and then that went to the Army Personnel Security Appeal Board, which also agreed. So Mr. Wonders sued in federal court as a civilian employee in what was starting with the MSPB and then going up to the Court of Claims. Court of Claims basically said, yeah, it's fine. Court of Appeals for the Federal Circuit looked at it and said, wait a minute. His clearance was revoked without him knowing the real reasons, without him seeing the documents that were the basis for the denial or for the revocation. This would have led to a fatal error in his clearance process were it not for the fact that DOHA had stopped the process and said, until you release this information to him, we're not going to pretend to have a hearing. We're not going to have a meaningful hearing. That would be like the hearings that were happening from 1947 to 1959. We're not going to do that. We're going to make sure that he has that information. Then we're going to have a hearing. Now, the result turned out to be the same, but the difference was, and the Federal Circuit's very clear about this in Army versus Wonders, a 2016 case, that the difference was that the DOHA decision was based on Mr. Wonders having input after having seen all the evidence against him. The Army PSAB decision was the result of a record in which Mr. Wonders got to present everything he wanted based on all the information that had been gathered against him. And that's what made it fair. Same outcome, but the process was fixed. And so what I want to say, I should say corrected, because fixed is being used in lots of different ways these days. I don't mean fixed, I mean corrected. So with that said, the process turns out to be really important. And so the process that comes at the end of investigation and adjudication needs to take into account everything that is going to be relevant to a personnel security decision and everything that puts the individual on notice as to what we're actually using to decide the case. Now, I'll give you another example. We had a case a while back in the civilian and military context where somebody who had been a sailor, an enlisted sailor, very successful career. So successful, in fact, that he got invited to go to officer candidate school, and he did. So he was a Mustang. He was going to become an officer after 10 years of distinguished service as an enlisted sailor. But all of a sudden, he gets a statement of reasons, and all of a sudden, he gets his clearance revoked. And the reason that was given to him was, well, you, in high school, participated in a plot to plan a school shooting, and that we can't have somebody like that in our officer ranks. And he says, wait a minute, that was investigated by the local police when I was still in high school, and it was found to be not true. Well, sorry, we were not going to take your word for it. So fast forward to the DOHA hearing. He shows up, and it turns out what had happened is there's a 38-page police report about how this guy had been sitting at a lunch table with two of his friends right after the Columbine shooting. And they were doing what teenagers in that situation would do. Like, gosh, if this happened here, where would you hide? Would you try to get under a table, or would you try to go behind the lunch counter? What would you do? And at some point after that conversation, one of his interlocutors figured out that our subject was sleeping with his girlfriend. And so he decides that the way to get back at him is to say, well, that conversation, he was plotting a school shooting. Well, of course that was a lie. Both of them end up getting expelled because the school is taking no chances. The accuser then brings his other friend into it and gets him to say, well, you got to back up my story because now I'm getting in trouble too. And so the other guy backs up his story. Then he gets expelled too. The police are investigating all three of them. And in this 38-page police report, the OPM summary was basically the first 16 pages or so. It's on page 37 and 38 that it turns out that the police have figured out that these two clowns can't keep their story straight, that there was no plot, this guy was completely innocent, and then the two other idiots get charged with making a false police report. But that doesn't show up in the first 16 pages of the report, and as a result, that's what gets summarized, and nobody went back and looked at the earlier investigation. The earlier DSS investigation had actually got the complete police report, and it was sitting there in Boyers. Nobody looked at it. And so the sad thing is this guy brings it in because he's done a FOIA request, he's gotten the information, and he shows up at our hearing, and he's got the 38-page police report. Right? So very easy case to decide. Never should have had it in the first place. Right? We never should have had it in the first place. And when Matt talks about how we want people to have information without having to FOIA it or without having to make a Privacy Act request, that's what he's talking about. That's what he's talking about. Executive Order 13764. It's the second of the two clearance reform executive orders. The first one is Executive Order 13467. And if you're thinking, wow, those are the same digits, just in a different order, yeah, we didn't plan that. That actually just came up in the random selection of executive order numbers when it was time for the second clearance reform executive order to get signed out in January of 2017. And so Executive Order 13764 has in it a provision that says that for due process cases, it is absolutely appropriate to make a direct release to the subject of their entire investigative file. Right? That's a right that never existed before, but it's there now. It's part of clearance reform. So when Matt talks about how we're trying to make sure that in Trusted Workforce 2.0, we're going to do that comprehensively, that is true. And it's really important. So with that said, I haven't touched on some of the other areas of Trusted Workforce, but credentialing, CAC eligibility, as we call it in DoD. For most of the policies I've talked about SEED 4, I've talked about SEED 5. SEED 3 is, of course, the reporting directive. Those are all from the Director of National Intelligence. The reason is the Director of National Intelligence under Executive Order 13467 is the security executive agent. They make the policy for both substance and process in the sensitive national security and security clearance eligibility world. Conversely, when you're talking about generic suitability for federal employment and federal credentialing, that's OPM. The Office of Personnel Management is the security executive agent for those lines of business. And so that's one of the reasons why the Performance Accountability Council has to exist, because they exist sort of in between the two, and they work with both. And they make sure that Trusted Workforce 2.0 is actually being done in a harmonized way. And it's really important. I see Kathy Ferguson up here in the front row. She has done great work behind the scenes, and many others in the Trusted Workforce 2.0 world of making sure that we are moving forward in a harmonious way. Because some of these things can't be exactly the same. I mean, obviously, civilian employees have MSPB rights. The contractor cleared population has rights under Executive Order 10865. Those rights are independent of what we do to reform the process. But the process deals with the vast bulk of the people. How many of you know how many people get cleared out of the total number of people who make either initial clearance applications or are reviewed now through CV? 98%. Who said 98%? Sir, you are correct. It's actually slightly more than 98%. It varies between 98% and 98.5%, but you're absolutely right. And that's important to understand, because while I can stand up here and talk to you about cases where we corrected a mistake at the due process stage, that's for less than 2% of the population. The vast majority, the focus quite correctly, is to do the case as fast as possible. Investigation and adjudication can and should, with all of the tools at our disposal, be faster and more efficient. And so Trusted Workforce 2.0 and clearance reform generally have been working toward those goals. You may remember that the Intelligence Reform and Terrorism Prevention Act made it the law of the land that a certain percentage of clearance cases had to be investigated within a set number of days and adjudicated within a set number of days. And those numbers, those ambitious numbers, have been met for the fastest 90% of the cases. And why is that? Because the fastest 90% of the cases aren't going to or shouldn't have to take that long. It's the last 10% that feed into the 2% where we're actually going to deny or revoke that are the ones that we need to take the time with. And so the process value shifts. For the fastest 90%, time is the process value. For the last 10%, getting it right is the process value, because now we've got issue resolution to worry about. Sir, you had your hand up.
Yeah, thanks. Quick question. So this is great that the employee gets all this protection and they get this time, and it's great. But as the industry who owns the risk and responsibility, putting compliance and so forth, this long, protracted process causes some challenges, right? So if we're focused that only 2% don't make it, so the people that are in the process likely have highly adverse adjudicated information. How does industry manage that risk when that sharing isn't there?
Well, you used a really important phrase there. You said likely have significant derogatory information. What I would say is that when there's issues to be resolved, it does not necessarily mean that it is significant adverse information. It just means that there are issues to be resolved. One of the things that DCSA has done well, and I see your hand is about to go up again, so I got to finish answering your last question before you can ask your next one. The DCSA has done something that I think is really cool, and it's been in cooperation with DOHA, which is that they've started for industry doing something that SEAD 4 has given them the ability to do, which is to grant conditional clearances. And to grant conditional clearances at the earlier stage in the process where it looks like there's a problem, where we started off with a pilot, which were just the statement of reasons that DOHA was rejecting, where we were saying, look, we understand there's an issue, but it's mitigated. And so we're not going to issue an SOR based on something that we think is already mitigated. But yeah, we get it that there's a problem. And so those are the people who are going to be subjected to continuous evaluation, continuous vetting, and at the same time, DCSA can say, but we've got you on a conditional, so if you violate the conditions, then we can take action. But at the same, so in other words, you're not absorbing the risk, we are. Now, that having been said, the assumption that somebody who is in due process is a risk. I'll give you a number from the military and civilian cases, and I'm going to give you a number from industry. The civilian and military cases, what we discovered when we studied this over the last 3 years, working towards some of the reforms for the service members and civilians that we've done, was that over 54% of the cases in which a service member or civilian had their eligibility denied or revoked and then appealed through DOHA to a PSAB were getting overturned. In other words, more than half of the denial or revocations weren't valid. They were being changed. But it was because we were gaining more information at the hearing. And so it wasn't that the adjudicators were wrong. It was that we learned more information so that DOHA and the PSAB could make a more informed decision that was positive. So that information gathering is not something that you want to skip over. And when I hear folks in industry say, well, we just need to know what the bad stuff is, like, yeah, but which bad stuff? Because the Privacy Act says before we give you information, we need to make sure that it's right, and we need to make sure that it's complete. The word complete appears in the Privacy Act when it talks about third-party disclosures. So, boy, I actually am getting into more legal stuff. Thank you, sir. But the thing that is really important to remember is that there are cases where the initial thing looks bad, and financial cases, huge, I mean, by the thousands, we see financial cases where the rest of the story means, yeah, they had circumstances beyond their control, they acted responsibly, it's perfectly fine. A lot of former service members have had predatory lending practices, have been the victims of predatory lending practices. Many people in our cleared population, because of the OPM data breach and other data breaches, have had their identity stolen. So the revision to SEED 4 in June of 2017 includes adding to that mitigating condition identity theft and being the victim of predatory lending practices. A lot of service members, when they show up at their first base, they have lots of people who are willing to lend them money, including car dealers, who will put them on a bus to a car dealership 30, 40, 50 miles away, and then when they don't buy a car, they discover the bus doesn't go back the other way. So they end up buying a car at 21% interest. Right? They've been the victim of a predatory lending practice. That's a great way to start your military and federal career. It happens to thousands of people. So the other one, and Lindy, I see you getting up, which means that my time is up, but I need to give you one more example, and this is the one that I closed with 2 years ago, and I'm going to close with it now because it is super important. Marijuana. I promised you I would talk about marijuana. This lady was an assistant U.S. attorney whose job was to prosecute drug cases. She was also an only child who was taking care of her mother. Her mother was dying of cancer. Her mother lived in a state, and she lived in a state in which medical marijuana was legal. And the doctors prescribed medical marijuana for palliative care, for pain and nausea and so on. This lady is now faced with the problem. She's got a security clearance through the Department of Justice, and I learned about this because the Department of Justice people and I talk, and I heard about it. She walks into the security office with the prescriptions in hand and says, I might have a problem because technically I am involved with marijuana. She got an SOR, right? I mean, for her pains, she got SOR'd. But at the end of the process, and Justice assured me that this happened, she got cleared. Because that's exactly the person that we want. I mean, SEED 3 isn't that specific, but by golly, when you've got somebody who's willing to say, I may have a problem, and I need you security people to know about it, I need you government to know about it, so that you can assess the risk, that's the person that I want in my trusted workforce. All right.
Woo,
Thank you.
good.
Thank you. Thank you. Thank you.